Today, let's talk about the nature and effect of obligations. Okay, so Article 1163. Article 1163, every person obliged to give something is also obliged to take care of it with proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So, the provision no here refers to the real obligation. So meaning the obligation to give something. So if a person is bound to deliver something like money, goods, or property, that person is also bound to preserve and protect it until delivery. Now, the standard of care required is that of a good father of a family, meaning an ordinary, prudent, and responsible person under the circumstances. Now, before we proceed on the obligations no, of a debtor in an obligation to give, let's identify first the things, no? The types of things para masabta nato unsa man ang mga things. Now, we have here um, type of things. We have specific or determinate thing. We have generic and limited generic thing. Now, in specific or determinate thing class, this is particularly designated or physically segregated from all others of the same class. No, meaning it can be identified by its individuality. Take note that it cannot be substituted against the obliger's will. So, an example, the watch I am wearing, so the very specific watch that I am wearing, or the car sold by X, or my dog named Luna, or the Toyota car with plate number AAV316. So it is very specific. With regards to generic class, this is an object which is designated only by its class, genus, or species. So it can be substituted by any of the same class and the same kind. So, example, a Bulova calendar watch. So, any Bulova calendar watch. A 2016 Toyota car. So, whether it's red, white, or blue, as long as it's 2016 Toyota car. Then, a police dog. Okay? So, when we talk of limited generic thing, this is when the generic objects are confined to a particular class. So, same with generic thing, it can be substituted by any of the same particular class. Now, let's distinguish specific thing from generic thing. A determinate thing is identified by its individuality. The debtor cannot substitute it with another, although the latter is of the same kind and quality, without the consent of the creditor. A generic thing is identified only by its species. The debtor can give anything of the same class as long as it is of the same kind. So, example, if S's obligation is to deliver to B a Rolex calendar watch, S can deliver any watch as long as it is a Rolex with calendar. Now, if S's obligation is to deliver to B a particular watch, the one S is wearing, S cannot substitute it with another watch without B's consent, nor can B require S to deliver another watch without S's consent, although it may be of the same kind and value. Now, if S's obligation is to deliver to B one of his cars, the object refers to a class which in itself is determinate. Here, the particular thing to be delivered is determinable without the need of a new contract between the parties. Now, it becomes determinate upon its delivery. So, need na to class distinguish ang specific thing o generic thing because inig-abot sa laws manggod. No? Uh, If it is a very specific thing and the thing is lost due to fortuitous event without the fault of the debtor, then the obligation to deliver the thing is extinguished. But if it is generic, since generic thing never perish, the obligation is not extinguished because you can substitute generic thing. The debtor can be compelled to deliver a such thing of the same kind and of the same value. Okay, now you take note of that. Now let's talk about duties. Now duties of a debtor in an obligation to give. So let's first talk about obligation to give a determinate thing, which is under Article 1163, 1164, and 1166 of the Civil Code. Number one duty of a debtor in an obligation to give a determinate thing is to preserve or take care of the thing due with the proper diligence of a good father of a family. So, what is this diligence of a good father of a family? So, this is a standard of care which an owner would give to his own property, unless the law requires or the parties agrees otherwise. No, so there is another standard of care. So if the law or the stipulation of the parties provides for another standard of care, like greater or extraordinary diligence, or less or slight diligence, said law or stipulation must prevail. Now, under the law, for instance, a common carrier or a person or company engaged in the transportation of persons and or cargoes, they are bound to carry the passengers safely as far as human care and foresight can provide, using utmost extraordinary diligence of a very cautious persons, with a due regard for all the circumstances. And in case of accident, therefore, the common carrier will be liable if it exercise only ordinary diligence of uh, the diligence of a good father of a family. Now, the parties may agree diligence again, which is more or less than that of a good father of a family, but it is contrary to public policy to stipulate for absolute exception from liability of the obligor for any fault or negligence on his part. Now, the factors that needs to be considered in this is the diligence that is required necessarily. No, that would depend upon the nature of the obligation and corresponds with the circumstances of a person, of time, and of the place. So it is not necessarily the standard of care one always uses in the protection of his property. As a general rule, the debtor is not liable if his failure to preserve the thing is not due to his fault or negligence, but due to fortuitous event or force majeure. So, example, S binds himself to deliver a specific horse to B on a certain date. And pending delivery, S has the additional or accessory duty, no, to take care of the horse with the diligence of a good father of a family. So, unsa man na, like feeding the horse regularly, keeping it in a safe place, etc. So, in other words, S must exercise that diligence which he could exercise over another horse belonging to him and which he is not under obligation to deliver to B. But S cannot relieve himself from liability in case of loss by claiming that he exercised the same degree of care toward the horse as he would toward his own, if such care is less than what is required by the circumstances. So if the horse dies or is lost or becomes sick as a consequence of S's failure to exercise proper diligence, he shall be liable to B for damages. The accessory obligation to S to make to rather to take care of the horse is demandable even if no mention thereof in the contract. No? So the what is the reason of this obligation of the debtor? So here, the debtor must exercise diligence to ensure that the thing to be delivered would subsist in the same condition as it was when the obligation was contracted, Without the accessory duty to take care of the thing, the debtor would be able to afford being negligent, and he would not be liable even if the property is lost or destroyed, thus rendering illusory the obligation to give. So you take note of that one. Now, another obligation, or rather duties of a debtor in an obligation to give a determinate thing, is to deliver the thing itself. So, the very thing imong i-deliver, because again, it's specific. Then, to deliver the fruits of the thing, to deliver its accessions and accessories. So, when we see accessions, this is everything which is produced by a thing or which is incorporated or attached thereto, excluding fruits. Accessories, these are the things designed for the embellishment or use or preservation of another thing of more importance. And then, of course, to pay damages in case of breach. So, na ay 5, okay? Ka-obligation or duties of the debtor in an obligation to give a determinate thing. So, this is one of the reason as well, class, nga kinahanglan natong i-distinguish ang specific or determinate thing versus generic thing. Because the duty of a debtor in an obligation to deliver a generic thing is only 2. Kung 5 sa determinate thing, 2 sa generic thing. This is to deliver the thing of the quality intended by the parties, taking into consideration the purpose of the obligation, intent of the parties, and other circumstances, and to pay damages in case of breach of the obligation. Here, class, that creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. Of course, while we talk about the duties of a debtor in an obligation to give, then we also talk about the rights of the creditor. So, in an obligation to do or not to do. So, to do, this is positive personal. The obligee is entitled to have the thing done in the proper manner by himself or by a third person at the expense of the obligor. Another is to demand what has been poorly done be undone, and to recover damages because of breach of the obligation. When it is a negative personal obligation, an obligation not to do, to have the thing undone or at the expense of the obligor, and or to ask for damages. You take note of that, class. Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. So let's talk about kinds of fruits. No? We have 3 kinds of fruits. Natural fruits, these are the spontaneous products of the soil and the young and the other products of animals. So examples are grass, all trees and plants and lands produced without the intervention of human labor. With regards to industrial fruits, these are those produced by lands of any kind through cultivation or labor. So example, sugar cane, vegetable, rice, and all products of lands brought about by reason of human labor. We also have civil fruits. So these are those derived by virtue of a juridical relation. So examples are rents of buildings, prices of leases of lands and other property, and the amount of perpetual or life annuities or other similar income. So, unsa may right sa creditor to the fruits? Okay, so we have the creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery arises. The intention of the law is to protect the interest of the obligee should the obligor commit delay, purposely or otherwise, in the fulfillment of his obligation. Now, when is the obligation to deliver fruits arises? Okay, so number 1, generally, the obligation to deliver the thing due, and consequently the fruits thereof, if any, arises from the time of the perfection of the contract. So perfection in this case refers to the birth of the contract or the meeting of the minds between the parties. Second, if the obligation is subject to a suspensive condition or period, it arises upon the fulfillment of a condition or arrival of the term. However, parties may make a stipulation to the contrary as regards the right of the creditor to the fruits of the thing. So, need na i-emphasize or expressly stated sa contract clause. In a contract of sale, the obligation arises from the perfection of the contract, even if the obligation is subject to a suspensive condition or suspensive period where the price has been paid. You take note of that. In an obligation to give arising from law, quasi-contracts, delicts, and quasi-delicts, the time of the performance is determined by the specific provisions of the law applicable. Okay, we have here an example. S sold S sold horse to B for 15,000. No date or condition was stipulated for the delivery of the horse. While still in the possession of S, the horse gave birth to a colt. So question, who has the right to a colt? Okay, so here, again, in a contract of sale, all the fruit shall pertain to the vendee or the buyer from the day on which the contract was perfected. So hence B is entitled to the colt. This holds true even if the delivery is subject to a suspensive condition like upon the demand of B, or a suspensive period like next month, if of course B paid the price. But take note, S has a right to the colt if it was born before the obligation to deliver the horse has arisen, and B has not yet paid the purchase price. So, in this case, upon the fulfillment of the condition or the arrival of the period, S does not have S does not have to give the colt, and B is not obliged to pay legal interest on the price since the colt and the interest are deemed to have been mutually compensated. So here, the colt belongs to B, not S, under Article 1537 of the New Civil Code. Because the contract of sale was perfected, the colt here is considered a fruit, no? A natural fruit of the horse. The fruit belongs to the buyer from the moment the contract is perfected, even before delivery. You take note of that, class. Let's talk about the meaning of personal right and real right. Now, when we talk of personal right, this is the right or power of a person to demand from another as a definite passive subject the fulfillment of the latter's obligation to do, to give, or not to do. While real right is the right or interest of a person over a specific thing like ownership, possession, and mortgage, without a definite passive subject against whom the right may be personally enforced. Note, class, that in personal right there is a definite active subject and a definite passive subject, while in real right there is only one definite active subject without any passive subject. A personal right is therefore binding and enforceable only against a particular person, while real right is directed against the whole world. So, example, X is the owner of a parcel of land under a Torrens title registered in his name in the Registry of Property. His ownership is a real right directed against anybody. So here there is no definite passive subject. Now, if the land is claimed by Y who takes possession, X has a personal right to recover from Y as a definite passive subject. So, if the same land is mortgaged to X by Z, the mortgage, if duly registered, is binding against third person, A a purchaser buys the land subject to mortgage, which is a real right. You have to take note of this, class. So, ownership acquired by delivery. Now, ownership and other real rights over property are acquired and transmitted in consequence of certain contracts or tradition or delivery. So in sale, for example, mere agreement on the terms thereof does not affect or effect transfer of ownership of the thing sold in the absence of delivery, either actual or constructive, of a thing. Now, the meaning of a phrase, he shall acquire no real right over it until the same has been delivered to him, is that the creditor does not become the owner until a specific thing has been delivered to him. Now, take note of this actual or constructive delivery, class. When we talk of actual delivery, is imo jud na gi-deliver ang thing, no, either specific or generic. While in constructive, only a symbol, like for example a car, no. So if you give him the key, bisan wala pa ang car mismo ma-deliver, then there is constructive delivery. So example, S is obliged to give to B on July 25 a particular horse. Before July 25, B has no right over the horse. B will acquire a personal right against S to fulfill his obligation only from July 25. Now, if the horse is delivered on July 30, B acquires ownership or real right only from that date. But if on July 20, S sold and delivered the same horse to C, who is a third person, meaning he is not a party to the contract between S and B, and C here acted in good faith, so meaning wala siya knowledge of the contract between S and B, then C acquires ownership over the horse and he shall be entitled to it against B. S, of course, shall be liable to B for damages. Okay? Ning promise naman siya nga adto niya ihatag or i-deliver. Let's talk about Article 1165. Article 1165 says when what is to be delivered is a determinate thing, the creditor, in addition to the right granted by him in Article 1170, may compel the debtor to make the delivery. If the thing is determinate or generic, he may ask that the obligation be compelled with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for fortuitous event until he has effected delivery. Now, there are remedies, class, of creditor in real obligation. Okay, number one, in a specific real obligation, so meaning obligation to deliver a determinate thing, the creditor may exercise the following remedies or rights in case the debtor fails to comply with his obligation. So there are three. No? Number one, demand specific thing or a specific performance or fulfillment. So if, of course, it is still possible. The obligation with a right to indemnify for damages, or demand rescission or cancellation, like in certain cases of the obligation, also with a right to recover damages, or demand payment of damages only where it is the only feasible remedy. Take note, class, that an obligation to deliver a determinate thing, the very thing itself must be delivered. Consequently, only the debtor can comply with the obligation. This is the reason why the creditor is granted the right to compel the debtor to make the delivery. So we have an example. S sells his piano to B for 20,000. If S refuses to comply with his obligation to deliver the piano, B can bring an action for fulfillment or rescission of the obligation with a payment of damages in either case. So in case of rescission, the parties must return each other what they have received. Now, The rights to demand fulfillment and recession with damages are alternative, not cumulative. So, meaning the election of one is a waiver of the right to resort to the other. So, B may bring an action for damages only if this is not expressly mentioned by Article 1165. Second, remedies, no? If it is a generic real obligation, meaning an obligation to deliver a generic thing. So, it can be performed by a third person since the object is expressed only according to its family or genus. It is thus not necessary for the creditor to compel the debtor to make the delivery, although he may ask for performance of the obligation. In any case, the creditor has the right to recover damages under Article 1170 in case of breach or violation of the obligation. Now, the manner of compliance with an obligation to deliver a generic thing class is governed by Article 1246. So Article 1246 says when the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. So example, S obliged himself to deliver to B 10 sacks of rice on December 4 for 100,000. So if S does not comply with his obligation, B may buy rice from C, who is a third person. If B paid C 10,000, he may recover. So assuming B has not yet paid S, the 10,000 from S. Furthermore, B can also hold S liable for damages in view of Article 1170 as in the case of delivery of a determinate thing. Now, when debtor delays or has promised delivery to separate creditors. So, paragraph 3 gives two instances when a fortuitous event does not exempt the debtor from responsibility. It likewise refers to a determinate thing. An indeterminate thing cannot be object of destruction by a fortuitous event because genus non comperit or genus never perish. So, again, class, if the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for fortuitous event until he has effected delivery. Kaya diba again, kung generic thing ra na sadya, it will never perish. So maalidsan ra siya of a thing of the same kind and of the same quality. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Now, let's talk about the meaning of accessions and accessories. Accessions are the fruits of a thing or addition to or improvements upon the thing, so meaning the principal. Example, house or trees on a land, rents of a building, air conditioner in a car, profits or dividends accruing from shares of stocks, and etc. Now, accessories are the things joined to or included with the principal thing for the latter's embellishment, better use, or completion. So example, key of a house, frame of a picture, bracelet of a watch, machinery in a factory, and bow of a violin. Now note, class, that while accessions are not necessary to the principal thing, the accessory and the principal thing must go together. Both can exist only in relation to the principal. Accession is also used in the sense of right, like the right to the fruits and or accessories of a thing. So, what are the rights of creditors to accessories and accessions? The general rule, all accessions and accessories are considered included in the obligation to deliver a determinate thing, although they may not have been mentioned in the contract. This rule is based on the principle of law that the accessory follows the principal. In order that they will be excluded, there must be stipulation to that effect. unless otherwise stipulated class, an obligation to deliver the accessions and accessories of a thing does not include the latter. Thus, a sale of an improvements like the house upon a land is not sufficient to convey title or any right to the land. But the lease of a building or house naturally includes the lease of the lot on which it is constructed, for the possession of a lot is implied in the lease of the improvement. Okay? You take note of that. Okay. Article 1167. If a person obliged to do something fails to do it, the same shall be executed as at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. A note class that Article 1167 refers to an obligation to do, like to perform an act or render a service. So it contemplates three situations. No? The debtor fails to perform an obligation to do. The debtor performs obligation to do but is contrary to the terms thereof, or the debtor performs an obligation to do but in a poor manner. Now, there are remedies of creditor in positive personal obligations. Number one, if the debtor fails to comply with his obligation to do, the creditor has the right to, one, have the obligation performed by himself or by another unless personal considerations are involved at the expense of the debtor, and of course to recover damages. Second is, in case the obligation is done in contravention of the terms of the same or is poorly done, then the court may order, so of course upon complaint, that it be undone if it is still possible to undo what has done. Now, if the debtor fails to perform the obligation to do, note that the creditor could ask someone else, like a third person, to perform the obligation to do at the expense, of course, of the debtor. Take note of Article 1167. Article 1168. When the obligation consists of not doing, and the obligor does what has been forbidden him, it shall also be undone at his expense. Now, the remedies of creditor class in negative personal obligation. So, negative personal obligation is obligation not to do, diba? So, in an obligation not to do, the duty of the obligor is to abstain from the act. So, it's not to do man. Here, there is no specific performance. The very obligation is fulfilled in not doing what is forbidden. Now, as a rule, the remedy of the obligee is the undoing of the forbidden thing, plus, of course, damages. However, if it is not possible to undo what was done, either physically or legally, or because of the rights acquired by third persons who acted in good faith, or for some other reasons, his remedy is an action for damages caused by the debtor's violation of his obligation. You take note also of this class. So, natay example para mas masabtan. Okay, example. B bought a land from S. It was stipulated that S would not construct a fence on a certain portion of his land adjoining that sold to B. So, should S construct a fence in violation of the agreement, B can bring an action to have the fence removed at the expense of S. Okay, so you take note of that. Article 1169 class covers the delay, its meaning, kinds, and its effect. So the first sentence of the article states the general rule where the obligor is in delay if the obligee demands already the fulfillment of their obligation, but it is also indicated in the latter part that there are situations where we could consider automatic delays even without the demand of the creditor. Now, let's discuss the meaning of delay. So, in legal parlance, the word delay, as used in the law, is not to be understood according to its meaning in common parlance. A distinction, therefore, should be made between ordinary delay and legal delay, or the default or mora in the performance of an obligation. So we have here ordinary delay. This is merely the failure to perform an obligation on time. Then we have legal delay or default or mora. This is the failure to perform an obligation on time, which failure constitutes a breach of the obligation. Now, let's talk about or discuss about kinds of delay or default. So they are, number one, mora solvendi, or the delay in on the part of the debtor to fulfill his obligation, either to give or to do. Then we have mora accipiende, or the delay on the part of the creditor to accept the performance of the obligation, and compensation more, or the delay of the obligors in reciprocal obligation, so like sale. So the delay of the obligor cancels the delay of the obligee and vice versa. The net result is that there is no actionable default on the part of both parties. Now, note class that there is no delay in negative personal obligation. In an obligation not to do, non-fulfillment may take place, but delay is impossible, for the debtor fulfills by not doing what has been forbidden him. So, there are requisites class of delay or default by the debtor. Conditions, no? 3 conditions that must be present before a mora solvendi can exist or its effect may arise. Number 1, failure of the debtor to perform his positive obligation on the date agreed upon. Second is demand. So, demand here is not mere reminder or notice. You take note. Demand made by the creditor upon the debtor to comply with his obligation, which demand may either judicial, so meaning when a complaint is filed in court, or extrajudicial when it is made outside of the court, either oral or in writing, and failure of the debtor to comply with such demand. Now, the above instances class presupposes that the obligation is already due and demandable. Of course, the creditor has the burden of proving that demand has been made. Similarly, it is incumbent upon the debtor to prove that delay was not caused by his fault to relieve himself from liability. Okay, so natin example. S obliged himself to deliver to B a specific refrigerator on December 10, 2022. So if S does not deliver the refrigerator on December 10, 2022, he is only in ordinary delay in the absence of any demand from B, although a period has been fixed for the fulfillment of the obligation. So the law presumes that B is just giving S an extension of time within which to deliver the refrigerator. So hence, there is no breach of obligation and S is not liable for damages. However, if a demand is made upon S by B on December 15, 2022, and S fails to deliver the refrigerator, S is considered in default only from that date. Now, if an action for specific performance, for example, is filed by B on December 20, 2022, the payment of damages for the default must commence on December 15 when he made the extrajudicial demand and not on December 20. In the absence of evidence as to such extrajudicial demand, the effects of default from the date of the judicial demand, that is from the filing of the complaint. Okay, you take note of that. Okay, so let's talk about effects of delay. So in the case of mora solvendi, the following are the effects. 1, the debtor is guilty of breach of the obligation. Second, he is liable for interest in case of obligations to pay money. So that's in Article 2209. Or damages in other obligations. in Article 1170. In the absence of extrajudicial demand, the interest shall commence from the filing of the complaint. And number 3, he is liable even for a fortuitous event when the obligation is to deliver a determinate thing. However, if the debtor can prove that the loss would have resulted just the same even if he had not been in default, the court may equitably mitigate the damages. So, in an obligation to deliver a generic thing class, the debtor is not relieved from liability or loss due to a fortuitous event. Because again, generic thing never perish. So, he can still be compelled to deliver a thing of the same kind or held liable for damages. Now, in the case of mora acipiende, the following are the effects. Number 1, the creditor is guilty of breach of obligation. He is liable for damages suffered, if any, by the debtor. He bears the risk of loss of the thing due, that's in Article 1162. And where the obligation is to pay money, the debtor is not liable for interest from the time the creditors delay, and the debtor may release himself from the obligation by the consignation of the thing or sum due. Kaya diba, sa mora acipiende, it is the creditor who incurs delay. Now, in case of compensation morae, meaning silang duha delay, no? Naka-cause of delay, the following are the effects. The delay of the obligor cancels the delay of the obligee and vice versa. So, legally speaking, there is no default or delay on the part of both parties. Now, if the delay of one party is followed by that of the other, the liability of the first infractor shall be equitably tempered or balanced by the courts. If it cannot be determined which of the parties is guilty of delay, the contract shall be deemed extinguished and each shall bear his own damages. You take note of that, class. Now, let's talk about when demand is not necessary to put debtors or debtor in delay. So, diba, kay as a general rule, delay by the debtor begins only from the moment a demand, judicial or extrajudicial, so for the fulfillment of the former's obligation is made by the creditor. So, without such amount, the effect of the default will not rise. So, of course, there are exceptions. So, exceptions when dili na necessary nga magdemand pa to put the debtor in delay. Number 1 is when the obligation so provides. So, for example, when D promised to see the sum of 20,000 on or before November 30 without the need of any demand. So, therefore, if D fails to pay on November 30, he is automatically in default. In this case, the parties already stipulates to dispense with the demand. Second is when the law so provides. So, example, under the law, taxes should be paid on or before a specific date. Otherwise, penalties and surcharge are imposed without the need of demand for payment by the government. And another is when the partner is liable for the fruits of the thing he may have promised to contribute to the partnership from the time they should have been delivered without the need of any demand. Third instance when demand is not necessary to put debtor in delay is when time is of the essence. So, example, the delivery of balloons on a particular date when a children's party will be held. So, and then like the making of a wedding dress where the wedding is scheduled at a certain time, or the payment of money at a particular time so that the creditor could pay off certain debts due on the same date, or the delivery of a car to be used in a trip at a particular time, and etc. Now, in the foregoing cases, the debtor is fully aware that the performance of the obligation after the designated time would no longer no longer benefit the creditor. So, in agreements of this kind, time element is important as performance itself. When the time of performance is not fixed or stated in general or indefinite terms, time is, as a rule, not of the essence of the contract, in which case, performance must be made within a reasonable time. What is reasonable time will depend upon the circumstances of the particular case. It is not necessary for the contract to categorically state uh, that time is of the essence. So, take note that intent is already sufficient. Then, fourth is when that demand would be useless. So, example, when S obliged himself to deliver a specific horse to B on September 5, through S negligence or deliberate act or by reason of fortuitous event for which S has expressly bound himself responsible, the horse died on September 2. So under this situation, any demand for the delivery of the horse on September 5 would be useless as S has made it impossible for him to perform his obligation. So, note that demand is also unnecessary where it is apparent that it would be unavailing, as where there has been a prior absolute refusal by S or S has manifested an intention not to comply with his obligation. The number 5 is when there is performance by a reciprocal party, rather by a party in reciprocal obligations. So, in case of reciprocal obligations, the performance of one is conditioned upon the simultaneous fulfillment on the part of the other. So, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. This is compensation morae class. From the moment, however, a party fulfills or is ready to fulfill his obligation, then the delay by the other begins. Okay? Now, Article 1170. 1170. Those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who, in any manner, contravene the tenor thereof, are liable for damages. So, Article 1170 class lays down the general rule on liability for damages when a party fails to properly perform an obligation. So, in essence, when you enter into an obligation, like arising from law, contracts, delicts or quasi-delicts or quasi-contracts, you must comply with it in good faith and in accordance with its term. If you fail, the law imposes liability. Now let's discuss grounds for liability. Number one is fraud or deceit or dolo. This is deliberate or intentional evasion of the normal fulfillment of an obligation. So there are two kinds of fraud. The causal fraud or the dolo causante, which is a fraud in obtaining consent, and incidental fraud, the dolo incidente, which is committed in the performance of the obligation already existing. Another grounds for liability is negligence or fault or culpa. This is not intentional. It is any voluntary act or omission, there being no malice, which prevents the normal fulfillment of an obligation. Third is delay or mora. This is the failure to perform an obligation on time, and which failure constitute a breach of the obligation. And four, the contravention of the terms of the obligation. So, the violation of the terms and conditions stipulated in the obligation. The contravention class must not be due to a fortuitous event or force majeure. Now note that fraud is intentional and must be clearly proved. Waiver for future fraud is void. The liability for this cannot be mitigated. On the other hand, when we talk of negligence, this is not intentional and it is presumed from a violation of a contractual obligation. Liability for this may be reduced according to the circumstances. Now let's distinguish fraud and negligence. Okay? So in fraud, there is deliberate intention to cause damage or injury, while in negligence, there is no such intention. Waiver of future fraud or liability for future fraud is void, while such waiver may in certain sense be allowed in negligence. So fraud must be clearly proved, while negligence is presumed from the violation of a contractual obligation, and the liability for fraud cannot be mitigated or reduced by courts, while liability for negligence may be reduced according to the circumstances. In short, class article 1170 enforces accountability. So if you fail to live up to what was promised in a contract or obligation, whether intentionally, so meaning fraud, or just carelessly, which is negligence, whether delay or contravention, you must answer for damages. Now, 1171, this refers to incidental fraud. Now, note that the court has no power to mitigate or reduce the damages to be awarded. No? So, let's talk about the definition of fraud. Fraud is the deliberate or intentional evasion of the normal fulfillment of an obligations. Okay, so there are two types of fraud, as mentioned earlier: dolo causante and dolo incidente. Now, dolo causante class is directly causing the act, no? This is the type of fraud or deceit that directly causes another person to perform an act that results in harm. So, here the deceit is the primary cause of the victim's act. Now, example, when Juan tells Pedro that a certain piece of land he is selling is free of liens and fully owned by Juan. So relying on this, Pedro pays a large sum of money for the property. Later, it turns out that the land is mortgaged. So here, Juan's misrepresentation directly caused Pedro to give money, no, for a property he wouldn't have purchased otherwise. Take note that this is an example of dolo causante. Another is a doctor that forges medical certificates that allow someone to receive insurance benefits. So the deceit directly causes the insurance company to release the funds. With regards to dolo incidente, this is just incidental or indirect fraud. So this is the kind of deceit that is present but is not the direct cause of the harmful act. The act could have occurred even without the deceit, though the fraud might aggravate the consequences. Example, Maria buys a car from Luis. Luis tells her the car has a brand new engine. But even without this claim, Maria would have bought the car anyway. Later, the engine turns out to be old and defective. So here, Maria would have purchased the car even if she knew the truth. Luis's misrepresentation didn't cause the act of buying, but it affects the consequences, like he probably overpaid or got a defective car. Now, this is a kind of dolo incidente. Another example is a person lies about being a licensed contractor when doing home repairs, but the homeowner would have hired him anyway. So the lie didn't induce the contract but affects liability or damages. Okay, so you take note of that class. The effect of dolo causante is voidable and damages. So pabayron of damages, while sa dolo incidente only damages class. Now, there are requisites, no, for fraud to vitiate a contract. So it must have been employed by one contracting party upon the other. It must have induced the other party to enter into the contract. It must have been serious, and it must have resulted in damage or injury to the parties seeking annulment. Now, take note, class, that waiver of action for future fraud is void. It is void when one of the provisions of the contract contained an agreement that in case he committed a future fraud in the future, he would not be liable for it, or you cannot charge him for the fraud that he committed. So, take note, class, that according to time of commission, fraud could be past or future. So, again, a waiver of an action for fraud is void, so meaning no effect, as if there is no waiver at all, because it is against policy and law. A contrary rule would encourage the perpetration of fraud, because the obligor knows that even if he would commit fraud, he would not be liable for it, thus making the obligation illusory. However, the waiver of action for past fraud is valid. So, a past fraud can be the subject of a valid waiver because the waiver can be considered as an act of generosity on the part of the victim. The waiver must be expressed in a clear language which leaves no doubt as to the intention of the obligee to give up his rights against the obligor. Take note of this, class. Waiver of action for future fraud is void. However, waiver of action for past fraud is valid. Okay? 172. Responsibility arising from negligence in the performance of every kind of obligations is also demandable, but such liability may be regulated by the courts according to the circumstances. So, Article 1172, class, builds upon Article 1170. It specifically deals with negligence or culpa in the performance of obligations. Now, the key point here is negligence give rise to liability. So, even if there is no fraud or deliberate intent, a debtor who is careless is still answerable for damages. So, example, if a delivery service accidentally damaged the goods due to poor handling. Now, we have here responsibility arising from negligence. It can be demandable, no? The court take note that in the performance, again, of every kind of obligation, the debtor is liable for damages resulting from his negligence. So, the court here has a wide discretion in fixing the measure of damages. Unlike fraud, which cannot be waived or mitigated, negligence can be regulated by courts. So, here the courts consider the nature of obligation, the circumstances of the parties, and the degree of negligence, either ordinary or gross. No? Because ngano man nga naman ni flexibility. Now, negligence is not as serious as fraud because it is not deliberate, no? So, negligence can be minor or unavoidable at times. The laws allow the judge to temper or reduce the damages if full liability would be unfair. Now, take note also, class, that when both parties are negligent, the fault of one may cancel or neutralize the negligence of the other. So, waiver of validity of waiver arising from action from negligence. So, if ang future fraud gani void ang waiver, no? In negligence, waiver of action for future negligence is valid except where the nature of obligation requires extraordinary diligence, like that of a common carrier. Also, um, negligence showing bad faith is considered equivalent to fraud. So, therefore, it is void. No, this is the kind of negligence nga ma-attribute na or ma-equate na sa dya og fraud. So, mao nang ang waiver ni dya is void. So, what is an example of a valid waiver of action for future negligence? Example, a gym requires its members to sign a waiver stating that the gym is not liable for ordinary accidents, so like minor slips or sprains, that might occur while using the equipment. So, since this involve only ordinary diligence, then the waiver is valid. Now, um, waiver is not valid because extraordinary diligence is required. So an example of this is when a bus company, so like a common carrier, makes passengers sign a waiver that it will not be liable if the driver is negligent in driving. This waiver is void because common carriers are required by law to exercise extraordinary diligence in transporting passengers safely. With regards to waiver, which is not valid because negligence amounts to bad faith, meaning it is equivalent to fraud, like a warehouse operator makes a client sign a waiver excusing the operator from liability for any kind of negligence. Then later, the operator deliberately ignores safety protocols and stores highly flammable materials beside open flames, causing a fire that destroys the client's goods. So, since the negligence is so gross that it shows bad faith, the waiver is void and the operator is still liable. Okay? You take note of that, class. Okay. With regards to kinds of negligence, okay, let's talk about kinds of negligence according to the source of obligation. So we have three, no? We have culpa contractual or contractual negligence. This is negligence in contracts resulting in their breach. That's Article 1172. Now, take note that this kind of negligence is not a source of obligation. It merely makes the debtor liable for damages in view of his negligence in the fulfillment of a pre-existing obligation. Civil negligence or culpa achilleana, this is quasi-delict or tort or negligence which by itself is the source of an obligation between the parties, not so related before by any pre-existing contract. Then we have the criminal negligence or culpa criminal, this negligence resulting in the commission of a crime. Now, the same negligent act causing damages may produce civil liability arising from the crime under Article 100 of the Revised Penal Code. Article 100 of the Revised Penal Code says every person criminally liable for a felony is also civilly liable, or it can create an action for quasi-delict under Article 2176 of the Civil Code. Now, in negligence cases, class, the aggrieved party may choose between a criminal action under Article 100 of the Revised Penal Code or a civil action for damages under Article 2176 of the Civil Code. What is prohibited under Article 2177 of the Civil Code is to recover twice for the same negligent act. In culpa contractual class, again, this happens when one party in a contract fails to exercise due care, no, thereby breaching the contract. So the key point here is the negligence does not create a new obligation. Rather, it is the reason for the breach of an existing contractual obligation. Like example, a shipping company fails to handle cargo with due care, damaging the goods. So the obligation arises from the contract of carriage, and the negligence result in a breach of that contract. With regards to culpa achilleana or civil negligence, this is the negligence that is independent of any contract and by itself creates an obligation to repair the damage caused. Key point here is there is no pre-existing contractual relations between the parties. Now, the obligation to pay damages arises purely from the negligent act. Example is a driver carelessly runs a red light and hits a pedestrian. There is no contract between them, but the driver is liable to pay damages because of his quasi-delict. In culpa criminal or criminal negligence, the negligence that results in the commission of a crime. Key point, the wrongful act is punished under the revised penal code and the offender may be held both criminally and civilly liable. Now, example, a bus driver recklessly overspeeds, causing a fatal accident. The driver may be prosecuted for reckless imprudence resulting in homicide or a crime, and he is also liable for damages to the victim's family. Again, class, when we talk of culpa contractual, this is just a breach of contract. Civil negligence or culpa achilleana, this creates obligation even without contract. And criminal negligence or culpa criminal, this results in a punishable crime. Now, what is the effect of negligence? Okay, so let's talk about the effect of negligence on the part of the injured party. Question, suppose the creditor is also guilty of negligence. Can he recover damages? So, answer of that one, class, is in Article 2179 of the new Civil Code, which provides when the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. But if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be awarded. So, we have here an example. P is a passenger in a carefully driven bus. Without any warning, he jumped off the bus as a result of which he suffered injuries. So here, the bus company is not liable for damages because the cause of P's injury is his own negligence. Now, another example, suppose P was standing on the running board of the bus and was repeatedly told by the conductor to go inside, but he did not pay any attention. Suddenly, the bus swerved to the left to avoid collision with another vehicle, as a result of which P was thrown off the bus. At the time of the mishap, the driver was intoxicated and was driving recklessly at a very high rate of speed. So, in this case, P did not observe the diligence of a good father of a family to avoid injury to himself. Kaya dapat maglingkod siya sulod sa bus. But his contributory negligence does not bar the recovery for damages for his death or injury, since the proximate or direct cause thereof is the negligence of the common carrier. Take note that during the accident, the driver was intoxicated and was driving recklessly. But of course, the amount of damages, class, shall be equitably reduced. Now, another example, suppose in our second example, nagtindog si P sa running board and was repeatedly told to get inside. And then the bus rounded a curve, causing P to lose his balance and fall off the platform, sustaining injuries. Now, the bus at the same time of the accident was traveling at a moderate rate of speed, and there was no infraction of law and regulations, and P was only exposed to no greater danger than that in that particular mode of travel. So, dili reckless ang driver. It's just that muliko ra man gid siya, no, kay likoon man. So here, P cannot recover. He should have been on his guard against a contingency as natural as that of losing his balance to a greater or lesser extent when the bus rounded the curve. Okay, again, class ha. It is not necessary that the negligence of the defendant be the sole and exclusive cause of the injury for the plaintiff to be entitled to damages. What the law requires is that the defendant's negligence is a proximate cause or at least a contributory cause of the damage. Now, if the defendant's negligence substantially contributed to the harm, liability may still attach even if other factors, such as the plaintiff's contributory negligence, natural events, or acts of other parties, also played a role. Now, the courts generally apply the doctrine of proximate cause. The negligence must be a natural and continuous sequence, unbroken by any efficient intervening cause producing the injury. So, in cases where both parties are negligent, the doctrine of contributory negligence or comparative negligence may come in, reducing but not totally eliminating the defendant's liability. Of course, that would depend on the jurisdiction. But in our jurisdiction, maunay mahitabo, no? Um, Example, if a driver overspeeds and collides with another car whose driver was also careless, both may be negligent. The first driver cannot escape liability simply because the other driver also contributed to the accident. So in summary class, Article 1172 says that negligence is in any obligation creates liability. But unlike fraud, which is absolute, the courts may adjust liability depending on fairness and the facts of the case. Article 1173. The fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of a person, of the time, and of the place. When negligence shows bad faith, the provisions of Article 1171 and 2201 paragraph 2 shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Now, this article class defines what negligence or culpa is and sets the standard of care in fulfilling obligations. So, here, gidefine no, ang negligence. And of course, the standard of diligence that is required. So, if the law or contract specifies the diligence required, like common carriers that must exercise extraordinary diligence, that rule will apply. If none is specified, the default rule is the diligence of a good father of a family. That is the equivalent to the standard of an ordinarily prudent man or prudent person in civil law. So let's talk about the meaning of fault or negligence. According to our Supreme Court, negligence is a failure to observe for the protection of the interest of another person that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. Take note, class, that there is test of negligence. No? Did the actor in doing the alleged of negligent act use reasonable care and caution which an ordinarily prudent person would have used in the same situation? If not, then he is guilty of negligence. Take note, class, that Note class that negligence is a question of fact. No? So again, negligence is the failure to exercise the care required by the nature of the obligation. So it is not determined by abstract theory alone. Courts must look into the actual circumstances of each case. Therefore, whether negligence exists or not is a question of fact, not a pure question of law. So, example, a driver hits a pedestrian. So, the issue of negligence depends on the facts. Was the driver speeding? Was the pedestrian jaywalking? Was it daytime or nighttime? So, in failure to observe due care, so again, when we talk of negligence, this is the absence of due care for the protection of the rights and interests of others. So, it is not just simply making a mistake, but failing to act as a reasonably prudent person would in the same situation. Example, a warehouse man fails to lock a storage facility, leading to theft or of stored goods. So here, his failure to exercise the ordinary diligence expected in his role makes him negligent. Now, note that the diligence required is not always the same. No, it depends on the particular obligation. So, if the law prescribes diligence, then follow the law, like extraordinary diligence for common careers under Article 1733. Then, if the contract prescribes diligence, then follow the contract. If neither law nor contract specifies, then apply the diligence of a good father of a family, or what we call the ordinary prudence. Because every situation is unique, the court cannot automatically label an act negligent without examining again the nature of the obligation, the actions or omissions of the obligor, the circumstances of person, time, and place, the expected diligence under the law or contract. Only after establishing these facts can the court determine whether negligence occurred. No, you take note of that. Again, the standard of diligence depends on law, contract, or in default, the good father of a family rule. Now, since negligence is a question of fact, meaning its meaning its existence is being dependent upon the particular circumstances, there is no hard and fast rule for measuring degree of care. So generally, the degree of care is graduated to the danger or risk a person or property may be subjected to. Now, in determining the issue of negligence, the following factors must be considered. Number one, the nature of obligation. So, this is the kind of obligation a person assumes dictates the level of diligence required. So, example, smoking while carrying materials known to be inflammable constituted negligence. So, smoking while doing so is negligence because the act is inherently dangerous given the obligation's nature. Now, the principle enunciated here is the riskier or more delicate the obligation, the higher the degree of care required. Next is circumstances of the person. So, the personal attributes, condition, or role of the obligor are taken into account. Example, a security guard who is strong, healthy, and in the prime of life, but sleeps while on duty, no? Is negligent because his role demands vigilance. So, the principle here is if one holds a position that requires alertness, knowledge, or skill, failing to live up to that standard constitutes negligence. Number 3, circumstances of time. Now, note class that time affects whether an act is considered negligent or not. Okay, so example, driving a car without headlights at night. So Of course, that is gross negligence because visibility is necessary in darkness. But driving without headlights during the day is not, since headlights rather aren't needed in broad daylight. So what is the principle here? What is safe at one time may be unsafe at another. Fourth, circumstances of the place. So the location determines whether an act is reckless or acceptable. Example, driving at 100 kilometers per hour is normal or permissible on an expressway designed for speed. But doing the same in a crowded urban area like Makat, uh, Ayala Avenue, Makati is reckless, or even ang kaning gawas no sa atong school. It is gross recklessness since heavy traffic and pedestrian make such speed dangerous. So, the principle here is the safety of an act depends heavily on the environment in which it is done. So, Article 1173 class tells us that negligence is relative. It cannot be judged in the abstract. Courts must always look at the nature of obligation, no? What the obligation requires, the capacity, role, or duty of the obligor, then when it happened, so the time factor, and where it happened, or the place factor. This approach ensures that negligence is judged fairly based on context, not by rigid rules. Now we have measures of liability for damages. Damages signify the money compensation awarded to a party for loss or injury resulting from breach of contract or obligation by the other. Now, the purpose of awarding damages is to place the innocent party in the same position he would have occupied if the contract or obligation had been performed according to its term. Article 2201 of the Civil Code states, obligor who acted in good faith is liable for natural and probable consequences of the breach of obligation, while obligor in bad faith or who acted in bad faith, malice, or wanton attitude is responsible for all damages. General rule class, the standard of care required is the diligence of a good father of a family. Of course, there are exceptions when other standards of care are necessary. Okay, number one, in common carriers. So they are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them. That's in Article 1733. Then hotel and innkeepers. The keepers of hotels or inns shall be responsible for the deposit of effects made by travelers as depositaries, provided that notice was given to them or their employees of such effects, and that they take precautions relative to the care and vigilance of their effects. That's Article 1998 of the Civil Code. This responsibility shall include the loss of or injury to the personal property of the guests caused by the servants or employees of the keepers of hotel or inns, as well as strangers, but not which may proceed from any force majeure. Another is with banks. No? Banks have the obligation to treat the accounts of its clients meticulously and with the highest degree of care. Then we have pharmacists as active players in the field of dispensing medicines to the public. The highest degree of care and diligence is expected of them. Now, what is the test of negligence? No? So I think we have mentioned that a while ago. The test of negligence is whether or not the defendant, in doing the alleged negligent act, observed the reasonable care and caution which an ordinary and prudent person would have used in the same situation. If not, then he is guilty of negligence. So, na-mention na po ni natong kinds of diligence required. No? Diligence is the attention and care required of a person in a given situation. Whether or not the negligence of the obligor is excusable will depend on the degree of diligence required of them. Under Article 1173, the following kinds of diligence are required: agreed upon by the parties, either orally or in writing. In the absence of the stipulation that required by law is the particular care. In a particular case, like the extraordinary diligence required of common careers, and if both the contract and law are silent, then again the diligence expected of a good father of a family. Now, with regards to renunciation of negligence class, the waiver of an action for past or future negligence is again valid. Parties can freely stipulate waiving liability due to negligence, but such stipulation must be construed against the party claiming the benefit of exception. Article 1174. Okay, except in cases expressly specified by law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption or risk that no person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. Now, this article class talks about fortuitous event. No? So, what is the meaning of fortuitous event? A fortuitous event is any event which cannot be foreseen or which, though foreseen, is inevitable. Stated otherwise, it is an event which is either impossible to foresee or impossible to avoid. Now, the essence of fortuitous event consists of being happening independent of the will of the debtor, and which happening makes the normal fulfillment of the obligation impossible. So, unsa may effect aning fortuitous event class? General rule: if the obligor is unable to comply with his obligation by reason of fortuitous event, his obligation is extinguished. Take note, class, that this can only be applied to determinate obligations. Because again, generic thing never perish. So if generic ganing obligation or generic ang thing no sa obligation, then such is not extinguished because the debtor can be compelled to deliver or to give the same kind and of the same value. Now, let's distinguish fortuitous event from force majeure. So, a fortuitous event may either be an act of man or an act of God. So, acts of man, strictly speaking, fortuitous event is an event independent on the will of the obligor, but not of other human wills. So, some example, ani. So, we have war, fire, robbery, murder, insurrection, etc. When we say acts of God, they refer to what is called force majeure, or those events which are totally independent of the will of every human being. So we have earthquake, flood, rain, shipwreck, lightning, eruption of volcano, and etc. In our law, in the Philippines, fortuitous event and force majeure are identical insofar as they exempt an obligor from liability. Both are independent of the will of the obligor. Now, let's talk about kinds of fortuitous event. So we have ordinary, fortuitous, and extraordinary. So Ordinary, this is common and which the contracting parties could reasonably foresee, like rain. An extraordinary fortuitous events, this is uncommon and which the contracting parties could not have reasonably foreseen, like earthquake, fire, war, pestilence, and unusual flood. So there are requisites, no, of a fortuitous event. Number one, it must be independent of the human will or at least of the debtor's will. The event could not be foreseen, or if foreseen, it is inevitable. The event must of such character as to render it impossible for the debtor to comply with his obligation in normal manner, and the debtor must be free from any participation in or the aggravation of the injury to the creditor, that if there is no concurrent negligence on his part. Now, absence of any of the above requisites, all of which must be proved, would prevent the obligor from being exempt from liability. So, naiusa ni mawala class, then dili exempt sa liability ang obligor or debtor. Mere pecuniary inability or poverty is not an excuse for the non-fulfillment of an obligation. Neither is mere difficulty to foresee the happening of an event. It is independent from the impossibility to foresee the same. As stated earlier, the event must be unforeseeable, or even if it could be foreseen, must be impossible to avoid. Now, let's talk about rules as to liability in case of fortuitous event. General rule, again, a person is not responsible for loss or damage caused to another resulting from the non-performance of his obligation due to a fortuitous event. So here, the obligation is extinguished, except when expressly specified by law. Then, like when the debtor is guilty of fraud, negligence, or delay or contravention of the tenor of the obligation, the debtor has promised to deliver the same specific thing to two or more persons who do not have the same interest. The obligation to deliver a specific thing arises from a crime, and the thing to be delivered is generic. And when it is declared by stipulation. Third is when the nature of the obligation requires the assumption of risks. Note, risk of loss or damage is an essential element in the obligation. So, example, number 3. B insured his house against fire for 100,000 with C, an insurance company. Later, the house was destroyed by accidental fire. Although the cost of the loss is a fortuitous event, B may recover the amount of the policy. So in a contract of insurance, the insurer, C here, in consideration of the premium paid by the insured, undertakes to indemnify the latter for the loss of the thing insured by reason of the peril insured against, even if the cause of the loss is a fortuitous event. When we see assumption of risk class, the ordinarily requires knowledge and appreciation of the risk and a voluntary choice to encounter it. The obligor or debtor with full knowledge of the risk voluntarily enters into some relation with the obligee or creditor. So based on the doctrine volente non fit injuria, no wrong is done to one who consents. On 175, usurious transactions shall be governed by special law. So this article class deals with usury, or the charging of interest beyond what is allowed by law. It tells us that the civil code does not set the interest rate limits itself. Instead, it defers to special law on usury. So Article 1175 says usury is governed by special law, not the civil code itself. So today, while interest ceilings are lifted, courts still have the power to strike down unconscionable interest rates in the interest of equity and justice. So, Well, this article is governed by special law. We have to discuss meaning of simple loan or mutuom, since mao man na siya ang nai-interest, no? Simple loan or mutuom is a contract whereby one of the parties delivers to another money or other consumable thing upon the condition that the same amount of the same kind and quality shall be paid. It may be gratuitous or with the stipulation to pay interest. So, gratuitous meaning walay money involved. So, usury is contracting for or receiving interest in excess of the amount allowed by law for the loan or forbearance of money, goods, chattels, or credits. Now, there are requisites class to recover interest. So, in order that interest may be recovered, the following requisite must be present. Number one, the payment of interest must be expressly stipulated. The agreement must be in writing, and the interest must be lawful. So, a stipulation for the payment of usurious interest is void. That is, if there are no stipulation as to the interest. The lender may still recover the principal of the loan and demand compliance with other terms of the contract otherwise valid. So, what is the law that is applicable in this? The law governing usurious transactions is the usury law. And the following are the maximum lawful rates of interest under the usury law which may be charged for loan or forbearance of money. So 12% per annum. So if the security given is a real estate, the title to which is duly recorded or government securities. Then 14% per annum if the security is given unregistered real estate or personal property or when there is no security. Then for pawnbrokers, 2.5% a month if the loan is less than 500, 2% a month if the loan is 500 to 2,000, and 14% per annum if the loan is more than 2,000. The usury law has been rendered legally ineffective by resolution number 224 dated December 3, 1982 of the Monetary Board of the Central Bank, and later by Central Bank Circular number 905, which took effect on January 1, 1983. These circulars removed the ceiling on interest rates for secured and unsecured loans regardless of maturity. The effect of these circulars is to allow the parties to agree on any interest that may be charged on a loan. The interest imposed should be in writing, no? So dili pwedeng wala naka-stipulate sa contract. Now, under circular number 799, the Monetary Board declared that effective July 1, 2013, the rate of interest for the loan or forbearance of money, goods, or credits, and the rate allowed in judgment in the absence of an express agreement as to such of interest, it shall be 6% per annum. Okay? You take note of this class. So, kanang mga 5, 6, or unsa pa na din ha, 25%, those are considered usurious. So, if moabot na sila korte, the court can actually temper that interest. No? Okay. 1166. Okay, Article 1176. The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments had been paid. Now note class that these are mere presumptions. So to be sure, write the interest and the dates covered by such payment in the receipt. Article 1176 class deals with the legal presumption in obligations, particularly on payments. It protects debtors from repeated demands by creditors once certain payments are accepted without qualification. So, there are two main presumptions in Article 1176 class. One, the receipt of principal, so presumption of interest paid. If the creditor receives the principal amount of the debt without any reservation about unpaid interest, the law presumes the interest has already been settled. So, example, a debtor owes 100,000 plus 12% interest. If the creditor accepts 100,000, meaning the principal, without saying this does not include interest, it is presumed that the interest is already paid. Second presumption is receipt of later installment. So, the presumption of earlier installment is already paid. So, if a debt is payable in installment, so diba, uso man na magbayad ng installment, and the creditor accepts a later installment without reservation as to prior ones, the law presumes the earlier installments were already paid. Example, debtor must pay 100 or rather 10,000 monthly from January to June. So if the creditor accepts payment for May without saying April is still unpaid, the law presumes January to April are already settled. Now, note, however, that again, these are only disputable presumptions, not conclusive ones. So the creditor can present evidence to prove otherwise, like show receipts or statement of account. Now, the idea is to avoid injustice to the debtor if the creditor accepts payment without protest. Fairness dictates that the law assumes prior obligations are met. Now, the rule encourages creditors to be vigilant in stating reservations when receiving payments. Now, while we're talking about presumption, let's talk about the meaning of presumption. Now, in legal parlance class, a presumption is an inference that the law or the court draws from a fact that is known or proven to conclude the existence of another fact. Now, they are generally classified into two. We have conclusive presumption or the absolute presumption. One that the law does not allow to be contradicted even with evidence. So it is final and binding, whether true or not, because it is grounded on public policy or established legal principles. Example, the law presumes that a minor below 15 years old cannot commit a crime. Or the presumption that a letter duly mailed was received by the addressee if properly sent. Second is disputable or rebuttable presumption. One that may be contradicted or overcome by presenting proof to the contrary, like that presumption established in Article 1176. So, again, these are presumptions of fact which hold true until disproved. So, in Article 1176, if the creditor receives the principal without reservation, interest is presumed paid, but creditor can rebut this by showing no interest was actually paid. Another is a person found in possession of stolen goods is presumed to be the thief, but the presumption may be rebutted by proof of lawful acquisition. So, in summary class, conclusive presumption, it is absolute, it cannot be contested, while disputable presumption, it stands unless rebutted with evidence. Now, when presumptions on the Article 1176 does not apply. 1. With reservation to the interest. The reservation may be made in writing or verbally. Second, receipt of a part of principal. So, this applies to the receipt of the last installment of the entire capital, not a mere fraction thereof. Or receipt without indication of a particular installment paid. The article is not applicable if the receipt does not recite that it was issued for the particular installment due and when the receipt is only dated. Then payment of taxes. So the article does not apply to payment of taxes. Taxes payable by the year are not installments of the same obligation. The non-payment proven. So this is where the non-payment of the prior obligations has been proven. Between a proven fact and a presumption pro tanto, to that extent, the former stands and the latter falls. Again, Article 1176 sets two presumptions in favor of the debtor. Accepting the principal without reservation, then the interest is presumed paid. Accepting a later installment without reservation, earlier installments are presumed paid. These presumptions, however, are not absolute and may be rebutted by clear proof to the contrary. You take note of Article 1176, class. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. So, 1177 class gives creditors remedies when the debtor refuses or fails to pay his obligation. The law does not leave the creditor helpless. It allows him to go after the debtor's property and even challenge fraudulent acts. Let's talk about the remedies available to creditors for the satisfaction of their claims. So, in case the debtor does not comply with his obligation, the creditor may avail himself of the following remedies. Number one, exact fulfillment or specific performance with rights to damages. Second, exhaustion of the debtor's properties still in his possession. This is a writ of attachment, or writ of execution. Then we have action subrogatoria. This is an action where the creditor whose claims had not been fully satisfied may go after the debtor or the third person of the defendant debtor. Then action poliana, an action where the creditor files an action in court for the rescission of acts or contracts entered into by the debtor designed to defraud them. Note, class, that the debtor is liable with all his property, present or future, for the fulfillment of his obligation, subject to the exceptions provided for by law. Now, let's talk about action subrogatoria. So, this is the right of the creditor to exercise all the rights and bring all the actions which his debtor may have against third persons. In order to satisfy their claim against the debtor, creditors have the following successive rights. To levy by attachment and execution upon all the property of the debtor except those exempt from execution, and to exercise all the rights and actions of the debtor except such as are inherently personal to him, and to ask for rescission of the contracts made by the debtor in fraud of their rights. There are requisites for action. Let's talk about the requisites now for action subrogatoria. The person to whom the right of action pertains must be indebted to the creditor. The debt is due and demandable. The creditor must be prejudiced by the failure of the debtor to collect his debts due him from third persons, either through malice or negligence, and the debtor's assets are insufficient or the debtor is insolvent, and the right of action is not purely personal to the debtor. So, take note, class, that previous approval of the court is not necessary to exercise action subrogatoria. Okay? Now, in simple words, class, when we talk of action subrogatoria, it's when a creditor steps into the shoes of the debtor to use the debtor's rights or claims against other people in order to collect what the debtor owes. So example, Juan owes Pedro 100,000, but Juan himself is owed 100,000 by Maria. So Juan refuses to collect from Maria, maybe because he is lazy or wants to defraud Pedro. Pedro, the creditor, can file an action subrogatoria to collect Juan's credit from Maria, so Pedro can be paid. Now, there is limitation on this. No? The creditor can only exercise property of patrimonial rights or rights with monetary value. He cannot exercise personal rights of the debtor, like the right to marry, the right to vote, the right to work in a profession. So in short, action subrogatoria, the creditor collects on behalf of the debtor, using the debtor's right, so that the debtor can pay what he owes. Okay? I hope nasabta na. Action Pollyanna class. The creditors may also impugn the acts which the debtor may have done to defraud them. That's Article 1177. Paragraph 3 of Article 1381, the following contracts are rescissible: those undertaken in fraud of creditors when the latter cannot in any other manner collect the dues due him. So the action to rescind contracts in fraud of creditors is known as action Pollyanna. Of course, there are requisites of this one class. Okay. Where there is a credit in favor of one plaintiff prior to the alienation by the debtor. The debtor has performed a subsequent contract conveying patrimonial benefit to a third person. The debtor's acts are fraudulent to the prejudice of the creditor. The creditor has no legal remedy to satisfy his claim, and the third person who received the property is an accomplice to the fraud. So, an action Pollyanna thus presupposes the following: a judgment, the issuance by the trial court of a writ of execution for the satisfaction of the judgment, and the failure of the sheriff to enforce and satisfy the judgment of the court. Now, note class that it requires that the creditor has exhausted the property of the debtor. The date of the decision of the trial court is immaterial. What is important is that the credit of the plaintiff antedates that of the fraudulent alienation by the debtor of his property. After all, the decision of the trial court against the debtor will retroact to the time when the debtor became indebted to the creditor. This is enunciated in the case of Sheng versus Court of Appeals. Now, action Pollyanna class, or a rescissory action, in simple words, is when a creditor asks the court to cancel or rescind a debtor's transaction that were done to defraud creditors. So, example, Anna owes Ben 200,000. So, instead of paying, Anna sells her house to her brother for 1 peso, just to avoid Ben collecting from her. So here, Ben can file an action Pollyanna to rescind or cancel that sale, so the house can again be used to satisfy Anna's debt. Now, there are limitations as well on this. It can only be used if the debtor has no more other properties left to satisfy the debt. It only applies to acts done in fraud of creditors, like fake sale. So, in our example, fake sale gid na laliman ka 1 peso ra pagbaligya, no? Or even donation gani and undervalued transfer. It is a last resort remedy class ang action Pollyanna. The creditor must first exhaust ordinary remedies like the execution against debtors' existing assets before resorting to action Pollyanna. Okay. Let's check no, the distinction of action subrogatoria and action poliana. So, in action subrogatoria, not necessarily that creditor's claim is prior to the acquisition of the right by the debtor. In action poliana, the credit must exist before the fraudulent act. Commentators have conflicting views on whether or not new debts contracted by the debtor fall under the scope of action poliana class. Now, in action subrogatoria, there is no need for fraudulent intent, while in action poliana, fraudulent intent is required if the contract rescinded is onerous. In action subrogatoria, there is no period of prescription, while action poliana prescribes in 4 years from the discovery of fraud. So we have here an example. On the due date, D could not pay C his obligation in the amount of 400. So, 400,000. However, D owns a car worth about 280,000 and X is indebted to him for 40,000. Before the due date of the obligation, D sold his land worth 200,000 to Y. So under the circumstances, the rights granted to C under the law are as follows. Number 1, he may bring an action for collection on the amount of 400,000 with the right to damages. Second, if in spite of the judgment rendered, D fails to pay the amount due, C can ask for the attachment of D's car so that the car may be sold and the payment made from the proceeds of the sale. Third, he may ask the court to order X not to pay D so that payment be made to him. No? Then, he may ask the court to rescind or cancel the sale made by D to Y on the ground that the transaction is fraudulent in case C cannot recover in any other manner of his credit. Now, take note class, the last remedy can be resorted to only if C could not collect his full credit. He must first exhaust the properties of the debtor or subrogate himself in the latter's transmissible right. So in summary, Article 1177 gives creditors 3 remedies, if the debtor fails to pay. 1. Go after the debtor's property. 2nd, exercise the debtor's right and actions. This is action subrogatoria, and invalidate fraudulent transfer made to defeat creditors. This is an action poliana. These remedies balance fairness, protecting creditors without unduly violating the debtor's personal right. Article 1178 class, subject to the laws, all rights acquired by virtue of an obligation are transmissible if there has been no stipulation to the contrary. Article 1178 class talks about transmissibility of obligations. General rule, all rights acquired by virtue of an obligation are transmissible. Contracts take effect only between the parties, their assigns, and their heirs, except those not transmissible by their nature, like purely personal rights, those not transmissible by provision of law, and those not transmissible by stipulation of the parties. So, transmissibility by right. So, when prohibited by law, like the rights in partnership, agency, and comodatum, which are purely personal in character. By the contract of partnership, 2 or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. By the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. And by the contract of comodatum, one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it, Comodatum is essentially gratuitous. And second is prohibited by stipulation of parties. So, um, when prohibited by stipulation of the parties, like the stipulation that upon the death of the creditor, the obligation shall be extinguished, or that the creditor cannot assign his credits to another. The stipulation against transmission must not be contrary to public policy. So, such stipulation, class being contrary to the general rule, must be clearly proved, or at the very least, clearly implied from the wordings or terms of the contract itself. Okay, take note of Article 1178. Okay, so I hope you understand the lessons that are being discussed, no, in this presentations. Again, this is the nature and effect of obligations. So the next lesson would be kinds of obligations. Thank you.